Hi, it's Mike DelSignore, and today I want to talk about the penalties you potentially could face if you're charged with domestic assault and battery. So in many of these cases, we shouldn't accept any plea. We should try to move the case for a dismissal if they can't prove the case, if there's no independent witness, if the victim's not on board, and there's no ways to prove the case, such as a 911, a statement from you, or someone else who saw the incident. Then our best bet is to move forward for a dismissal. But let's say the alleged victim is on board. What are the types of resolutions that we can have in these cases? Well, one is called the continuance without a finding, where you'd admit to sufficient facts and you'd be placed on probation. Generally, if you admit to a domestic assault and battery, most cases they're gonna want you to do what they call a batterers program. This is a certified program. The idea is to combat domestic assault and battery. It's a long program. There's a shorter program called the anger management program. A judge has to make written findings to waive the batterers program. So typically, if you're charged with some domestic offense or even a 209A violation, you're gonna have to do the batterers program. So one resolution is a continuance without a finding, it's technically not a conviction. Let's say you were charged with assault and battery with a dangerous weapon. That's a felony offense. So one of the things your attorney may want to do is try to amend the charge from a felony to a misdemeanor. I handle these cases all the time, and that's a common strategy is to, one, get the case out of a felony stage into a misdemeanor stage, and get it continued without a finding, which is technically not a conviction. If, let's say that the facts are more serious, you might have to be facing a conviction. If the facts are very serious, you have a bad record, you might be looking at jail time. So the scale of penalties obviously is committed time, guilty, continuance without a finding, and then sort of the lightest resolution short of any admission, short of a dismissal, will be what they call pretrial probation, where they continue the case for a certain period of time. If you agree to certain terms and conditions, stay out of trouble, maybe counseling, alcohol treatment, things like that, the case would eventually get dismissed. So the penalties can range when you're charged with domestic assault and battery. There are different types of charges that often accompany these charges, such as witness intimidation, strangulation, assault and battery with dangerous weapon and other felony offenses, and 209A violations. So sometimes someone charged with this offense may not just be charged with a single count, but might be a multiple count complaint. So keep in mind, if you're not a citizen, the charge like this could certainly have immigration consequences. So in light of these serious penalties, you want to make sure you consider fighting the case, taking it to trial. So what are some of the things you want to do to prepare for trial? One, if they're witnesses, we want to talk to the witnesses. Two, if they're legal issues, such as whether a 911 call is going to be admissible, we want to analyze the call. We want to put it on for a motion to eliminate to exclude this 911 call from evidence in the case. This is something that I do all the time. The U.S. Supreme Court has defined when statements can come in through a 911 call without the alleged victim showing up in court. This distinction depends on whether the statements fit in the category of testimonial versus non-testimonial evidence. It can be very fact-based, very specific based on each call. So it requires a motion before a judge prior to trial to determine whether this call will come in evidence. Sometimes there might be statements that can be suppressed to help your defense. You may have been interrogated by the police without them reading your Miranda rights, and that evidence can be suppressed and excluded from evidence in your trial. What I tell people charged with these offenses is right away, the best thing to do is certainly if the victim's on board or might be on board, if you can do some treatment, counseling, alcohol treatment, whatever the victim would say you need or whatever seems to be the problem, try to address it because it may help us reach a resolution in the case. And if we do go to trial and you're found guilty, make it less likely a judge gives you a harsher sentence if you take some steps up front well before the trial to show that you took this seriously, you've dealt with the problems in the case. So these charges, domestic assault and battery, really, I've represented people from all walks of life, people from all types of jobs. You know, it can happen in a relationship, and when it's charged, even if the victim's not on board, it's not going to get dismissed. You face really stiff penalties. So make sure you understand what to do, how to handle this case, move it through the court system most efficiently, so that you can move on with your life. My name's Mike DelSignore. I handle these cases all over Massachusetts. Be happy to help you. This is my passion, helping people charged with criminal cases get their life back together and avoid convictions and and achieve the best resolution for you in your case. I have to look at the case to determine how it might potentially come out, what's the best decision for you. But if the alleged victim's not on board, if you're married, a lot of times we can move for a dismissal or put the case on for trial to get the case dismissed. If they are on board, if there's other evidence, then we have to consider potential other options and other ways to resolve the case to avoid some of the more harsh penalties that could be associated with this type of charge. So feel free, reach out, call, text anytime. I'm here to help you. 781-686-5924.